All right, let's get started. If you're just joining us, this is the Creative Finance Collective. If you've never watched or been a part of the Creative Finance Collective, this is just a collection of attorneys from a variety of different jurisdictions that get together to talk about what's in the name, creative finance. We do it to help ourselves, to help learn creative finance from a variety of different lawyers from different jurisdictions, from different angles. And we do it for you. So if you have questions and you're watching the collective, we're here for the hour to take questions as best we can. Obviously, we're not lawyers in every state. We are licensed in our own respective states, and but we'll give you as best we can, kind of our understanding of an answer to the question with respect to our state, and always encourage you to get specific legal advice on a specific legal question. With that, how's everybody doing? We were talking a little bit earlier. Alan, you just jumped on. How you doing, Alan?
Doing well, doing well. I'm going to be a little bit of a short timer. Got to finish up a response to MSJ, but I wanted to say hey to everyone.
Now, wait a minute. I thought you weren't a litigating attorney.
I
You,
wish
you
I
got
wasn't.
dragged back in.
I wish I wasn't. I wish I wasn't. I've got a silly case up in Dallas regarding wrongful foreclosure, and I just want out.
Oh, all right. Alan, I don't know if you've met Natalia before. Natalia Ouellette-Grice.
Nice
She
to meet
is
you.
on here as well.
Hey there. Hey there. Where are you located?
Florida.
Okay, good deal.
Hmm.
Yes. Yeah. So now we got somebody from Florida to talk creative finance. So if you're watching who we have here, I'm Andy Fowler. I'm a licensed Arizona attorney. Elizabeth Best, Brian Locker, both Arizona attorneys. Brian is a Georgia attorney as well, and Natalia out of Florida. I wanted to start out and just read everybody some statistics I thought, because I think these are stats I heard just last week, and I thought it painted the picture for why we are where we are in creative finance and its popularity. But as of the end of last week, the median mortgage payment is $2,900. Now, these are national averages, not Arizona. Median rent is at $1,900. So to own a home now on average is more expensive than to rent. And I thought this was fascinating. I had to read this twice. I could hardly believe it. But it said, um, housing affordability just reached its lowest point in history. Since these stats have been tracked, it's at its lowest point in history. Even in the worst part of the 2008 financial crisis, affordability was 15% better than at its current levels. Um, I thought that was pretty staggering statistic to think about. Obviously, that's the result of high lending costs, high interest rates, and that's the result of high real estate prices, probably because nobody wants to sell their home because they all have sub 4 and 5% mortgages, which is why sub 2 is pretty popular. What is I, what are the markets? We'll start in Texas. Is Texas, has this affordability issue been a continued problem in Texas?
It is. Austin's a little bit different than the rest of the state, but we're what I call consumer or retail real estate is slowing. Investor real estate is still fast, but I'm getting a fantastic influx of calls with the end user seller to end user buyer type transactions, and it's funny because what they're doing is saying how can I sell this thing, but I don't want to lose my interest rate that I have here, so they're bouncing around the idea of a mortgage wrap. They just don't know that they are. And so we also I have people who are conventional mortgage lenders out there now marketing to real estate agents, teaching them about mortgage wraps and digging in. So people don't want to buy, they don't want to get mortgages, and sellers don't want to lose their interest rates. And so we have a what I call a pushing of both sellers and buyers over to this creative finance arena.
Yeah, it would make sense. Natalie, has this been sticky prices and interest rates in Florida as well?
Absolutely. In fact, there was a news article released mid last month about the top places in the country that are overpriced relative to affordability. And five of the top 10 cities are in the state of Florida. Tampa's there. That's where I'm at. It's number 9. So it's definitely a reality, a painful reality. I think Florida was a very, very popular place for people to come to during the pandemic as work became more and more flexible. And so the movement of people from the north, where generally home prices are higher, you sell your home there, you come down here, right? You make that new demand, and it made it an incredibly competitive area. So as soon as the feds were like, okay, we need to deal with this inflation, bump up the interest rates, now you've got pretty much all of the locals unable to afford housing, and the ones that are continuing to feed this boom are the people that continue to move from up north down here.
Brian, what about, I know you're just outside of Atlanta. What's it like there?
Yeah, a lot of I'll echo the sentiment for Texas and Florida. Georgia, I just had a client. I was talking to him about the deals that he's doing in the Atlanta area, and the sellers now are identifying the fact that these low interest rate mortgages that have been obtained over the last 5-6 years create so much value for potential buyers that they're actually advertising them now, and homes are going for above market rate because they're being advertised, especially loans like VA loans that specifically can be assumed.
Mm-hmm.
You're seeing huge jumps in potential value because people can get in on sub 3% mortgage rates in some instances on VA loans. And so I was consulting with him on an assumption of a VA loan that was at 2.5% interest, and so he was paying about 15% over current market value just to be able to secure that property with that loan. So it's crazy.
Well, we've talked about this idea that at some point sellers are going to figure out that the loan that they have is itself an asset and something to be marketed to attract investor buyers who, or maybe not even investors, maybe just regular buyers who want in on great rates. And given that home prices haven't plummeted, that they want to get in, maybe they'll even overpay to get cheap lending. I'm curious, Alan, I know you do a lot of closings, and I've wondered, we represent so many investor buyers and they're investors, but I've been waiting for, as this catches on, to start seeing more and more sellers who decide to do this, decide they like it, and then become a buyer. And in some sense, sometimes they almost have to, because there's credit issues with respect to this. You're still going to be carrying your own the old loan in your name and everything else. But as a closing attorney, are you starting to see repeat persons who were on the seller side and have now shifted to the buyer side, or is it still too early to really start seeing that in a significant way?
Not seeing it a bunch. I'm seeing folks that were not in the mortgage wrap arena coming into it, but not as the repeat. Now that the conventional mortgage lender fellow who's getting ready to go out there and mass market, that is what he's trying to produce. Is okay. We've educated the seller that, hey, our buyer wants to come in and take over your mortgage in some form or fashion. Then simultaneously, that seller is now going over to be a wrap buyer in the next purchase. So he's going to create the type of person that you're talking about. But I'm not seeing a lot of them, learn about the wrap via a buyer presenting the opportunity and then turn it into a wrap buyer. I'm not seeing a bunch yet.
Okay, interesting. What about anybody else seeing anything like that, where buyers are now? I've always thought that they might be forced into that scenario, given that it makes conventional lending more difficult if that old loan is still in your name. So why not just kind of adopt the strategy and just become a buyer and see if you can find similar deals? One of the things I wanted to bring up too, we had spoken about this, Brian, and since we have a litigation attorney here, I wanted to bring up and kind of get a temperature. What kind of, you handle a lot of our litigation matters, but are you handling any, or what kind of creative finance type litigation issues are you seeing pop up, or have you seen any pop up recently?
There's always litigation issues popping up. So a couple of issues that came just this week, just off the top of my head, and Elizabeth can speak to this one. We had, a pretty experienced buyer, a client of ours, who entered into a contract to purchase real estate, and we were preparing some documents for them, and Elizabeth was looking at the loan documents that were going to be assumed by the transaction, and she identified the fact, she's like, you realize that this loan you're trying to assume is a reverse mortgage, right? And
Oh God.
this experienced buyer just had completely just hadn't identified the fact that one of the loans was a reverse mortgage, because he was doing this outside of escrow. And so he was kind of doing his own title search almost, and just didn't see at the top of the loan statement that it said reverse mortgage on it. And so that was really interesting, because you could be put in a real bind as a buyer, all of a sudden faced with a mortgage debt that you have no interest in assuming anymore, but you're under contract. And so it's a good, and so you almost, we do a lot of specific performance actions on behalf of a buyer who has a non-performing seller. But something like this issue could put you in the reverse, whereas the buyer, you want out, and the seller's like, no, we have a deal. And could almost create a scenario where the buyer is desperately trying to get out of the transaction, as opposed to the other way around, which is what we normally see. So that's one issue. And then I had another issue come up in litigation where, and this is happening a lot of creative finance buyers are identifying their sellers because they happen to find out that someone is deceased. And there's, maybe there's a probate that had been filed, or what have you. Either way, there's been a death in the family, and so they approach the beneficiary, one or more of the beneficiaries, and say, hey, let me step in and take this headache off of your hands. Well, there's a strategy employed out there by some buyers where they will put one of the beneficiaries under contract, but that beneficiary has no ability at the time they sign the contract to bind the estate, right? And so the investor is then hoping that person is the one who gets appointed to be personal representative of the estate, so that they can then ratify that contract and close escrow. But what will often happen is, especially when you have animosity within the family and the various beneficiaries that are out there, you get a contract with one beneficiary, the other beneficiary has no interest in that contract and is the first one to get appointed as personal representative. Now you're stuck with a contract with someone who doesn't have anything other than an inherited contract, or someone who is, can purchase whatever percentage interest that person is about to receive from the sale of that property. And so what we've done is we've started actually, and Elizabeth's practice group has started providing language to our clients to insert into their contract, because the last thing you want is to have a contract as a buyer for the full fair market value of that property, when in reality you may be stuck in a scenario where you're only getting 50%, 33% or less of that property, but the purchase price is at full fair market value, right? And so we're providing language to put in these contracts to say, in the event that you have less than 100% interest in the property at the time of close, the purchase price will be adjusted downward to whatever percentage interest you actually have, so that you can at least so that transaction maybe still is worth doing for the buyer. And so we had a situation come up where that the buyer had to just get out of the contract because they had 100% interest and had a contract with someone who was only going to get 33% of that home. So anyways, those are two issues that just came up this week that is creating litigation for us in both Arizona and Georgia.
Interesting.
Yeah, you
If
definitely see partition issues arise with those heirs properties. I've
yeah.
had to deal with several of those partitions lately.
Yep.
Natalia, does your office do litigation, or you guys
Yes.
mostly transact? Okay.
Yes, we do. So I used to do transactions back when I was president of a title company. So I did transactions for about 10 years. Now I handle the real estate title and possession litigation. And so I see mostly the issues come up, and then we work with the investor to help them clean it up if they don't come to us beforehand for those special type of provisions that Brian was discussing, which are so important, right? Too often we've got investors who, to try to save a buck, download online forms, think that that's going to be the contract of their lifetime, and it ends up being the contract that puts them in the red. So if there's anything that I would encourage investors to do is to really understand the cost of having an attorney review and advise and address those things beforehand, as opposed to the litigation, is night and day.
Natalia, is Florida a lawyer closing state, or do?
So it's not a lawyer closing state. It is one where title companies can be owned by non-lawyers. And so there can be a lot of unique situations where title companies maybe don't understand the transaction. And also there are some title companies that are attorney owned, but that have it as part of like a personal injury practice or something that's not so real estate focused. And you can see a lot of mistakes happen on that end too. I would say, have somebody that's advocating just for you as a party, rather than relying on the closing agent to be the one to give you guidance.
If you are just joining us, this is the Creative Finance Collective. So we're talking about things relating to creative finance, whatever kind of floats our boat and comes up and we decide to discuss. But if you have questions and looking for an answer, make sure to ask away. We'll be happy to attack them as best we can. I have a question. It's from a buyer, but investor, but it says top question they get from sellers in a sub-2 transaction is, where does it say buyer will pay the existing loan? ? I think what they're referring to is in just a straight up sub-2 purchase agreement. So non-wrap related, probably related agreement. They're getting the question, well, where does it say you're going to pay this? This just says you're going to be buying this subject to. I don't really have the answer to that, depending on what document you use, but I think it's safe to say, and I could probably throw this to you, Alan, because you're the wrap guy. If you're using a wrap, it really answers that question, doesn't it?
Yeah. So in the contracting, I'd have to go look at it. I don't think it necessarily says I'm paying the monthly payment. It just says I'm taking over the mortgage and all the terms and conditions of the mortgage. But then in my promissory note, I definitely have a term in there that says the buyer is obligated for all of the terms and conditions, as well as to issue the monthly payment. And if they fail to issue the monthly payment, then this, that, and the other happens. So it's definitely embedded in my loan documents. I have a full set of loan documents for a sub-2 or assumption, same as a wrap, and they have substantially similar terms and conditions in there. So if you're closing with me, you have that obligation there. There's still folks that are doing the deed to secure assumption, and that's the only document they have, and there is no obligation to make that monthly payment, which I think is very, very bad to exist out there, and hopefully everyone's moving away from that. But yeah, they should be embedded in the terms of the loan documents.
Yeah. Another question from a listener. I'm a buyer in a sub-2 transaction. Will I be able to obtain information from the lender about the existing loans? What documents will I need for this? I think the answer is you're going to need documents, right?
You need authority, right? So you that's where you're thinking, a power of attorney that's specific to the transaction, that allows you to communicate, that allows you to request proof of where the loan is standing, seeing if there's been any other additional communications. Sometimes behind the scenes, people start talking about modifications, extensions. You want to be able to access that. You've got to have a power of attorney that says that you can access that information.
Yeah, and I think there's always going to be cooperation clauses in these agreements, but you're not going to want to leave it to the cooperation clause because right, the issue is these people are off to Tahiti after the sale, right? They're gone. You finding them's a whole nother problem. So you want the ability. I think we also, in addition to the power of attorney, Elizabeth, correct me if I'm wrong, probably like an authorization to release information as well.
I don't know about the authorization. I know we do the powers of attorney, and then we do like notices to the insurance and to the lender to change the contact information so that the buyer should be substituted in for the original owner.
Got it.
Yeah, we have an authorization document signed at closing, and then we also have a power of attorney that I call authorization on steroids, but it also takes care of authority to sign escrow refund or insurance payments is embedded in that power of attorney. But the authorization is designed to go to a mortgage company, change all contact information over to buyer, because our people don't go to Tahiti, they go to Madagascar, is what I say. And so when they're in Madagascar, we don't want to rely on that cooperation clause. We want full authority to that mortgage.
Yeah, that makes sense. Since you're here, I want to take the advantage of having a Florida attorney here. We've talked about, Alan and Libby will recall, we've probably talked a few times about the land trust and everything else, but I learned that the land trust is actually statutory in Florida. Do you like using the land trust? Is it popular to be used up in Florida on creative finance transactions? What are its benefits?
So I would say that in Florida, well-seasoned investors definitely use the Florida Land Trust. That's chapter 689.071 of the Florida statutes. And it's a very unique type of instrument because it's not just for anonymity, it's actually for liability purposes, the way that the act is written. So that it really helps with isolating the assets that are held by the land trust from the creditors of the beneficiary and the creditors of the trustee.
So is it the functional equivalent of the shield of liability that like an LLC provides?
It's almost, just with the privacy aspect, although we don't recommend here in Florida that somebody just use a standalone land trust as their shield, right? People will make the mistake of being the trustee and then the same beneficiary, and then what are you doing, right?
Yeah.
It's often used in conjunction with entities created in another jurisdiction that also embraces privacy, Nevada, Wyoming, Delaware. And the purpose of it is, not only do you get to enjoy the fact that maybe you're using it as a holding entity to not trigger the instant due on sale clause, right? If you've got a transaction from the person who's the seller to the person who's the same person, right, as a trustee, with the beneficiary behind the scenes being the actual purchaser of the property. But it's also become a way to minimize title closing transactions by, instead of conveying title, right, passing it via deed, you're conveying the beneficial interest behind the scenes. And that might be a way to incentivize, silent partners to come and help you fund a deal. So there's unique uses of land trust, but they're not a substitution for the other limitations of liability vehicles that are out there. I'd say there's something to use in conjunction.
Got it. We have another question. Can you have an agreement for sale / land contract, or land installment contract is another term for it, or contract for deed, automatically be turned into a sub-2 deal after a specific period of time, say 2 to 3 months? If so, what does it need to say? Why don't we just start in Texas, where they don't like the land installment contract?
Yeah, so a contract for deed, lease purchase option, what have you, if it's longer than 180 days and there's a underlying lender, you can't do them. Well, you can. You have to get approval from the underlying lender, which Mr. Wells or Mr. Fargo is not giving you that permission. So we don't like them. A clause in there, and I'm thinking from a title standpoint now, a clause in there that makes it automatically change. I don't think it's going to do anything for us. Title's going to want some type of conveyance instrument outside of that contract for deed. So I don't really care about the legal aspect of it. I think from the title aspect, it's not going to work. But that's just off the cuff.
Yeah,
Never
right.
contemplated it. I think you're going to have difficulty.
Natalia, do you see the agreement? Everybody seems to love the agreement for sale out there. It seems to come up a lot. Is it? You see that much there? Is it allowed in Florida?
So agreement for deeds are allowed in Florida, except they're treated exactly like a mortgage. So there's no differential treatment. If you do an agreement for deed, the person who's the buyer has equitable title. You're now stuck with a mortgage as a seller. And in order to, let's say, enforce that, if they become delinquent on it, now you've got to do a foreclosure proceeding. There's no getting around it. The case law for the state of Florida is pretty clear that, for example, those pre-executed deeds in lieu don't work here. That equity of redemption can't be gotten rid of that way. And so you can try it, but there's not going to be a difference in the treatment.
Okay. So in Florida, so they're automatically treated as a mortgage. So if you default on an agreement for sale, the remedy is a judicial foreclosure or
That's right.
okay, a mortgage. Okay. So Arizona has a body of statutes for agreements for sale that allow for what's called forfeiture. So you forfeit your interest in it so long as you follow basically so long as you agree to use a servicing company. If you don't use a servicing company to service the loan, you're forced to bring what's called a judicial forfeiture. So they have to forfeit their, it's kind of like a mortgage foreclosure. You got to bring an action, but it's called forfeiture instead of foreclosure. So doesn't sound like a lot of the answer to that question is going to be heavily state specific. What state you're in. Not only from a
in
legal,
Arizona, there's up to 6 months of notice you have to give in that case too.
And when you forfeit,
depending on how much has been paid on the obligation in the contract for deed.
And not only there's like. Not only does the legal question matter about whether you can and cannot do, but those legal answers will dictate sometimes the investment strategy too. Like this sounds like a good deal when you read about it online, but there can be a lot of problems. I mean, the real reason anybody only likes the agreement for sale, at least as it applied in Arizona, was this idea that in the quickest sense, you can achieve a forfeiture of, if you're the lender, you can get your property back or the equitable interest that's out there forfeited within like 30 days. And you can do it very cheaply through an affidavit, so long as you followed a certain set of guidelines. So it's very attractive from a time perspective to get that back. But there's a lot of other kind of unintended problems. And I was actually going to bring up bankruptcy, but bankruptcy is a problem with agreements for sale out there because you've got an executory contract where, title hasn't been passed. I mean, this would be more of an issue of depending on which party files bankruptcy, but a bankruptcy trustee can come in and monkey with an agreement for sale in a way that they can't when title's already been, bare naked legal title's been transferred. I wanted to find out from everybody. We like to, I was going to bring up the bankruptcy question, but how do you like to handle transactionally the event of the seller's potential bankruptcy after the closing of a subject to transaction. We have a provision where we like to just say that the seller's going to agree to reaffirm the debt in the event of bankruptcy. Have you approached it? I'll start with you, Alan. Have you approached that any different, or is that kind of the conventional wisdom on how to deal with a seller's bankruptcy?
Yeah, recently I created a new document, and it's just affirmation. In the event of bankruptcy, I forget what I title it, but it says seller will reaffirm the debt, and I even put in there that buyer is going to pay any costs associated with that reaffirmation. I don't think there's actually any costs associated with it, but it's designed to look like everyone's on the same team, sort of.
Yeah.
So I have that reaffirmation agreement that's now, a complete separate document. It was already embedded in some of the deed of trust language, but I pulled that out. I've only had about 3 or 4 cases where a seller is filing bankruptcy, and they've all come in except one and reaffirmed. And I have not spoken with the fellow that the buyer. They actually paid the reinstatement, got a deed to secure performance from the seller, and then the seller scurried off and filed bankruptcy. So there was no conveyance, no title closing that went, and so he got embroiled in bankruptcy litigation. So I need to circle back. So stay tuned next week. We'll circle back and give the answer as to what he went through.
Yeah, you might have issues there as a preferential creditor.
Yeah, he said it was wild. I just haven't had a chance to talk with him yet.
That's interesting. Oh, we got a cliffhanger. That's good. I like cliffhangers. All right. If you are just joining us, this is the Creative Finance Collective. We're talking about all things creative finance. So if you have a question, we've had a few, make sure, and we've got some more. But make sure to join us. Ask away. We're here for the hour, maybe another 20, 30 more minutes. So if you've got your questions, make sure to ask them. I've got a good one here. I know you'll like this one, Alan. What happens if there's a loss to the property and the property insurance is still in the seller's name after closing? I think the answer to that is, I don't think you want to know the answer to that. Maybe that's the answer.
Well, it's not in the seller's name, the insurance. So we're relatively Nazi-ish in terms of insurance getting put in place. I've got 2 people in Texas that I referred to. If the parties are not using one of those 2 people, they sign off on a document that releases and indemnifies my office for their mortgage wrap transaction failing. That's obviously designed to try to get them back over, because the insurance is the reason mortgage wraps fail, not the due on sale clause or things of that nature. And so the seller can't carry insurance on a property they don't own. They're an additional interest. So any insurance payment should be coming back to lender and owner of property. The buyer of the property may have some trouble and some difficulty working with the lender on that, but you're not going to have problems with the seller side. They're out and gone.
So long as you set it up correctly, right? It sounds like what you're saying.
Well, yeah, and I think that if an insurance company digs into it and figures out what's going on, seller has sold property, there's a new owner, I think insurance company is going to deny a claim. However, I've heard insurance companies where the seller remained as an insured party after the sale of the property, they actually paid a claim. I don't know why. I think they messed up because insurance companies, in my experience, like to say no. So I think that's going to be a basis to deny the claim every time.
Well, and we like to, correct me if I'm wrong, Elizabeth, we like to have the seller assign, right to any insurance proceeds anyway, in the event that takes place. I assume, is that right, Elizabeth?
Yep. And then we also have the power of attorney, the limited power of attorney that can also be brought to insurance and stuff.
Yeah. So, if you make these mistakes, it likely means you were doing it on your own, and you should rethink that strategy. Natalia, it sounded like you were in agreement with Alan. Have you seen
Yeah,
insurance problems?
it is so key to make sure that insurance is in place for the parties that are actually the owners. Then, if you want to have some additional insured in the background, always make sure that the mortgage lender is there named properly as an additional insured for the new policy. You don't want to be in default for that reason. But with the assignments that you all are talking about, like assignments of proceeds, not such a favorable mechanism anymore in Florida since we had tort reform law. It had to do with roofing and roofing contractors and assignment of proceeds for claims that were related to, oh, I see you've got this issue in your roof. Let's use that as a whole replacement and do an assignment of proceeds. So because of that and the change in the law, I would discourage people in the state of Florida from thinking that an assignment of proceeds is going to handle it, just because the new statutes do not favor assignments of proceeds clauses. But never, ever, ever, ever close something without making sure you have insurance in place securing you and your interests on a subject to transaction.
So one of the inherent problems that you're always going to run into, I think, in subject to transactions is that, somebody who's not that sold their home is still on a lot of these documents. I mean, and we've been talking about that. One of those is receiving end of the year tax forms from like the mortgage company. I'm thinking of like a form 1098. They come in and we try to address this in the documents as best we can with the seller, that they understand that that's going to happen and they're not supposed to claim that, just now that there's a buyer making the payments, they don't get to claim that interest. Do you guys ever run into problems with that or see issues with that where sellers get these 1098s and think that it's okay to claim that?
So what we do is advise the buyers. All contact information with the mortgage company is going over to you, address, email, phone, everything. So the seller should not be getting that 1098. And then secondarily, we advise that the ultimate payer of the mortgage is entitled to that tax benefit, and anyone who claims it who's not the ultimate payer of that is committing tax fraud. So we like to use that 5-letter F word that hopefully gets them to act correctly. If a seller wants to wrongfully claim that and risk it, then so be it. It doesn't affect our office, I don't think.
Okay. So we have let me get this. We've got a follow-up question to our earlier question. Let's see if I can, and the earlier question again was the agreement for sale. Can that automatically be turned into a sub 2 deal after a specific period of time, say 2 to 3 months? The follow-up is, so if I wanted to wait and record the deed, so if I wanted to wait and record the deed, just do a regular sub 2 and don't record the deed until I need to, and just put a lien against the house to protect my interest. Okay. I have a whole host of questions to that, I think, because on an agreement for sale, we're not recording a deed, right? We're holding it in escrow, usually. Let me read this one more time. Did that make sense to you guys?
Well, a little bit. A lot of times folks will not want to record the deed for different reasons.
Right.
And we just, vehemently advise them against that. Not recording that deed means the seller can go sell the property to someone else. It means that all the liens that are going to attach against the property because of that seller are going to attach and be in front of you. And we've seen that those exact scenarios happen, too often. So I won't close a file and not record that deed. Now I guess they can overrule me with a release and indemnification document, but it's just too dangerous.
Yeah, I'm seeing that now and reading it. It's in lieu of an agreement for sale, basically holding a deed, not recording it. you know, a recorded deed puts the world on notice and gives you priority ahead of, just like Alan said, you know, you'd be dealing with any potential liens that are out there. Now, um, he raises it, saying, well, maybe to protect his interest is put a lien against the house to protect that interest. Um, those are,
Then you
that's
get the
pretty.
doctrine of merger, possibly.
Yeah, well,
come into play.
I was thinking the same thing. So, you know, I was like, well, okay, if the deed's not recorded, but if you've got a deed in your name, but then you've got a lien, right? Yeah, you know, what Natalia is getting at, the lien merges with the deed and stop and no longer exists.
Correct. Just like you
And
can't do an easement for yourself.
right, yeah, right. And maybe nobody would know about that until you recorded it, but the second you recorded it, you know, the world would be on notice that it merges. Yeah. So I think that would, obviously we don't know what state you're in. You'd want to talk to a lawyer specifically about that. Let's see.
But that lien, that lien to secure your position is only going to secure your position in relation to a title insured closing and transaction. They can still go and deed that property to another person that doesn't know about the first deed.
Title. Mm-hmm.
They record that, and now they're a bona fide purchaser, and you can't beat them in Texas, obviously. So that lien just sort of protects you.
Yeah, priority of interest is so key, because as what he's saying is, you know, you want to be in a position where the entire world knows that you have a title interest in this property, and that any future potential liens that could have attached against the property because of the behavior of the prior owner of the seller are no longer effective, right? Because if you don't go and record that deed, seller could have a car accident. Now he's got a car accident judgment against them that attaches against the property, could default on his credit card. Now he's got a credit card judgment that attaches against the property, could have stopped paying child support. Now he's got a judgment so there's so much risk in not recording a deed.
Yeah.
So we have another question. I don't know the full context of this. So the question is there any protections for a junior liens in a foreclosure? What I don't know, that's a simple enough question, and I can answer it from one perspective. Alan or Natalia or Elizabeth, I don't know. I don't know if this question has in mind like a subject to wrap, where, you know, the secondary loan given to the lien given to the seller, for instance, of course, would be secondary and junior. And what protections might that have? You can explain that. But as a general rule, if you're just talking about junior liens, I mean, their primary protection is to the extent there's excess proceeds in the trustee sale. So, you know, if there's, and that's something usually a second position lender is going to want to know before they extend the loan. Okay, what's the value of the property? Do I feel adequately protected? Every dollar over the amount. If the first position lender is foreclosing and there's money that's in excess of their lien, that's excess proceeds that's going to go to you if you're second in position. So that's kind of the protections there. I mean, there's statutory protections giving them notice and everything else, but you're junior for a reason. You know, you're secondary to, you know, the number one. So, you know, not a lot, but I don't know if those same kind of concerns, I mean, those same issues apply in a sub two, where you're wrapping, but the wrap's a little bit different way to kind of conventionally think about it. It's more about getting your right back to get back onto the property and still be subject to the first. You disagree or see anything different about that, Alan, on wraps?
No, I mean it's you know, when if the first is foreclosing, the seller or investor that has that lien interest needs to go and reinstate that first and go after the property and foreclose if there's, you know, sufficient equity there, like you're talking about. But you know, in terms of priority, an interesting thing that occurred. Had an attorney going down doing a foreclosure, and it was the sub two that was foreclosing, and sub two lender seller wanted the property. And so what the attorney did was said, hey, we're foreclosing. This is a second lien foreclosure. Even though it was a mirror wrap, an exact wrap, it really wasn't a second lien position foreclosing, and that chilled all the other bidders at the foreclosure. So I thought it was a pretty ingenuitive way to get bidders to go away and the seller lender to get to recover the property and get extra equity in the property.
I like that.
I wish I could say that worked in Florida, but it is intensely competitive here on the foreclosure market. And you'd be amazed how many people are bidding at second and third position lien foreclosures, HOA foreclosures, county lien foreclosures.
Wow.
Knowing quite well that there's something superior to it. And these are going for nearly market rates.
Wow.
Yeah.
And so you're saying they're bidding on the second? Ugh. Are they doing that intentionally? Probably.
Some, yes. Yeah. Some use it specifically as a strategy because they got their negotiation skills down when it comes to dealing with a superior lender. Some just make the mistake of not hiring someone to do a title search beforehand.
Interesting. Interesting question. See what you guys think of this. How do you like to deal with this transactionally? But how can I prevent the seller from making statements to the existing lender that could cause the lender to call the loan due or initiate foreclosure proceedings? So we're talking about a pissed off seller the first thought that comes to mind is you could just make sure to properly disclose the nature of the transaction so they don't get mad. Beyond that, if you've done that properly, then anything's going to make them mad. So what do you guys like to do to mitigate against that? I mean, there's no way to really. It's like saying, how do I stop lightning from striking? You can't make this happen. But
we just draft up some impotent language in our document that says they won't go and frustrate the transaction. I mean, if they do, then what do you do? You have a cause of action against them for a breach. So it's more again perception of obligation versus actual obligation.
Yeah.
Yeah.
Yeah, and just to piggyback on that, I think that that highlights the importance of making sure that your seller is fully informed about the nature of their transaction.
Yeah.
The best way to prevent issues post closing and even pre closing is to properly inform the seller. The clients that I have that are involved in the most litigation are the ones who are the most vague, or I suspect are the most vague in their sales pitch. And you may think it's great because you're getting sellers to sign left and right, but then you end up hiring me to, pursue, multiple litigation cases for seller non-performance because they realize after the fact what they actually signed. Regardless of whether you presented them with a full contract, if you didn't present it properly, it's going to just create problems.
Yeah, and we're seeing a lot of that. We'll open a from the title side. We'll open a contract, do all the work, get all the way down to closing, and then there's a confused seller, and then they literally start yelling at us, talking about how we're stealing their property and such. And I'm like, hey, we're a title office, we're okay. So, and because of the prevalence of all the real estate gurus out there, I ain't saying anything good or bad about them. They just exist. And so we have very, very novice investors that are getting engaged in this without knowing the full aspects of it. And one of the primary needs is disclosure and education to these sellers or your buyers for that matter. If you're seller finance rep, you got to educate them, over-educate, over-disclose, same as in anything else in real estate. And so it's a problem now.
Yeah, one of the things I think there is this problem that given the influencers, the nature of a subject to transaction is it's an innovative thing and everything else, but you come away thinking that it's maybe a little bit easier than it is, and maybe the deal points are I mean, conceptually not all that difficult, right? But transactionally, this isn't something that ought to be done on a napkin, um, if you're doing it right. I mean, the disclosure list, I know, Alan, you got a lengthy disclosure, and there's reasons for it. There's reasons for it because when they come at you with a lawyer later, you wanna be able to show them the 83 times that they initialed, and we're fully aware of the transaction. We have another question. Um, if there is a mechanics lien, so jumping back to the foreclosure question, if there's a mechanics lien and the lender's foreclosing, can the lien holder in the mechanics lien cure the default? So I think what that means is can the lien holder come in and stop the first position lender from foreclosing? I think that's gonna come down to this. Obviously, it's gonna come down to the state. In Arizona, here, we have trustee sales, so private trustee sales, non-judicial, and there's a statute that defines interested parties, so parties that I have to put on notice as the trustee when I'm doing it. Those include lien holders and certain parties who have the right to reinstatement of the loan. So, the borrower can obviously reinstate the loan in Arizona anytime before 5 p.m. the day before the trustee sale, and there's nothing I can do as the trustee. There's nothing the lender can do to stop that other than to say, "Here's the total due, plus attorney's fees and everything else to do that." And there are interested parties that are also allowed to reinstate the loan. Same is true here with tax lien foreclosure sales. If there's other tax lien holders, they can come in and cure that. Now, whether you can get that back is another question, but I presume this means they're hoping to do that to stop the sale. What does that look like, or do you know in Texas and Florida?
Do you want to go ahead first, Alan?
Yeah.
Go for it, Natalia.
Okay. So in the state of Florida, junior lien holders have to be added to the foreclosure proceedings under the lis pendens statute. If you've got a recorded interest, you can intervene. And you do have an equity of redemption right as a junior lien holder. So you can go in and essentially put yourself in the position of the mortgage lender by paying off the indebtedness. That's how it works here in Florida.
I don't do as much foreclosure work, but I don't think we have the laws that y'all have there in Arizona in regard to that. And we certainly don't see mechanics lien holders want to come and protect their position in that way. But in my thinking, they would just go and simply purchase the mortgage. They're not required to reinstate after the 20-day notice of default. Once you get into the 21-day foreclosure time period, they don't have to reinstate.
In Texas, is it mortgage or deed of trust there?
Deed of trust.
Okay, deed of trust. Okay, yeah. So for those listening, when Natalia talks about redemption, that's a classic mortgage type term versus reinstatement is like a classic for some of the Western states, a deed of trust type term. Yeah, we do. Now we have mortgages. We have an entire body, a statute of mortgages, but nobody ever uses them. And that's where you might get redemption rights. But usually, that would be one interesting tactic to go buy the note. You'd probably, depending on what kind of deal you'd have to come up with more money. I've seen people as a strategy try to reinstate mortgages or a deed of trust, reinstate the loan. Boy, for that to pay off, it couldn't be, delinquent for a long period of time. And I feel like it's like how much you even owed on the mechanics lien. If it's usually they can't be that big to justify, I would think, paying reinstating, but maybe, but that's only a temporary fix in any case. If you bought the mortgage or bought the note, that would be permanent. But coming to the table probably with more money. Let's see. We got another question here. Brian, you got a fan. Hi, what is the name of the attorney wearing the red shirt? Well, first of all, he's married. No. Okay. So it says wearing the red shirt. And what state does he practice in? I don't see his info. Oh yeah. Yeah. I didn't put his name in the info. So his name is Brian Locker. Why don't you give your info, Brian? I'm not going to speak for you.
Thanks. My name is Brian Locker. I'm one of the partners at the law firm of Fowler St. Clair, and I am licensed to practice in both Arizona and Georgia, and I handle the real estate litigation for the firm.
Yeah, there you go. And if you send in your contact information, he'll send you a signed black and white photo. That'll be awesome.
My headshot's a little out of date, but
Yeah.
they're all out of date.
Yep.
Well, hey guys, we've been here for about an hour. I appreciate everybody coming. Alan, Natalia, Elizabeth, Brian. Thank you for your time. I know you've got valuable things to do. You got families and everything else. We appreciate it. Good discussion. Lots of questions. So that was super cool. Let's do it again.
All right.
sounds good.
Awesome.
Take care,
you for
everybody.
having us.
Yeah.
Thanks,
All
guys.
right. We'll see you guys next time.